Hafitz, who is a licensed clinical social worker who established MFJ's social work department in 2007 and has run it since. And it was created with senior MFJ attorneys with experience working with challenging populations. So this is a mix of clinical expertise from a mental health professional and expertise from longtime legal services providers. So when you're dealing with clients in housing court, you're going to have people with a lot of different issues. And the training is called Working with Clients with Mental Illness and Other Challenges, because a lot of people with mental illness do not have challenges that need to be accommodated in a different way. A lot of clients that you have will have challenges, even if they don't self-identify as a person with a mental illness or have a mental illness. Housing court has a lot of seniors, a lot of people with limited English proficiency, a lot of other issues that might make developing an attorney-client relationship difficult. And that also applies to, caseworkers and people working on getting them, FEPs, city FEPs, one-shot deals. But specifically with people with mental illness, 5% of people in the population of the United States have a serious and persistent mental illness, and 20% will have some sort of mental illness in a year. And the difference between that is serious and persistent mental illness is chronic. But mental illness can be very cyclical, and so some people will not be symptomatic for a period, and then they will become symptomatic for a period. Mental illness comes with a lot of co-occurring complications like medical issues, less education, poverty. People with mental illness die on average of 25 years earlier due to treatable medical conditions that they can't access for a variety of reasons. And those are all things to keep in mind when you're dealing with someone who self-identifies or has a mental illness in your work. The first thing that is so important to remember is that you have to assume anytime you have a client with a serious mental illness that they have the capacity to direct their case and they have the capacity to do what needs to be done in your case. So you be aware of stigma and bias, which are baked into every part of our society with regard to people with mental illness. And don't assume that you need to work with someone with a mental illness differently until either they ask you to or it becomes apparent that it needs to happen. And in a lot of cases, all you need to do is be flexible. It doesn't have to be a big, reasonable accommodation, formal process. You just may need to allow more time, more phone calls, more emails, longer meetings, forgive people for being late, missing meetings, that sort of thing. And we'll get into more detail specifically as we go forward, but it's important to state up front that not to make assumptions about clients who have mental illness. So the first thing we're going to talk about, Jessica, can you go to the next slide? Is establishing the relationship. And this point happens before you may know any challenges or limitations your client faces, and this applies to all clients that you work with. You want to be clear to the client and yourself that the goal is to listen to their issues, explain the process, and create an alliance with the client. This isn't easy, especially if you're doing high volume intakes and representation. And so that's why I said remind yourself, because there can be sort of a hamster wheel of getting clients in, getting clients out, getting clients in, getting clients out. And there's a lot of pressure to do that. And there's not a lot of support at a lot of agencies to put in the time that's necessary to establish the relationship. But that needs to be a priority, especially with clients who have a mental illness or elderly or otherwise have something that's going to be hard for them to work with you. Remember when you first have contact with a client or potential client that your office is like an ER, it's like an emergency room. They're in crisis. you are probably not their only crisis. Many of them are going to have crises with work, education, family, medical, psychiatric. Right now, there's obviously the crisis of COVID-19 and police brutality and the murders of Black Americans, which are going to affect many people, you know, psychiatrically and emotionally. So people who you're communicating with are likely going to be anxious and possibly angry, possibly very angry. A lot of them are also going to be very confused about the court process and your intake process. They may have dealt with a million different agencies with a million different rules about, first we do this, and then we do this, and we'll give you this paper, and then we'll take this paper from you, and then you won't hear from us for a month. And that's all really frustrating and confusing. So the very first thing to do with all clients is clarify who you are. What is your role? I'm an attorney. I'm a paralegal. I'm an intake officer. I'm a caseworker. Explain what that means, because the distinction is not known to a lot of people. And explain what you're doing. You're doing an intake, or you're investigating, or you're representing. And be clear what that means, because a lot of clients, if they talk to an attorney and you say, I'm investigating your case, they 100% will take that as, now you're my attorney. And it's your job as their advocate or potential advocate to say, I am not representing you yet. First, we have to do this step, and then we have to do another step. If it's possible, if you have the time, give the clients a few minutes to tell their story or what's on their mind, even if you're in a hurry. I'm sure you all have detailed intake lists that you have to complete, but giving the client the chance to frame their own story to you is really important, both for hearing what's important to them, which may be different from what's important to you and may affect your goals as their advocate, but also it does help establish the trust and the relationship, because a lot of our clients have not ever had anyone in a professional capacity listen to them. Avoid acronyms and legal terminology. That applies all the time, every day. Past establishing the relationship, it's extremely easy to get into talking about OSCs and OSDs and HRA and REU. Please avoid that. And once you've gotten past the initial intake, return phone calls and emails within 24 hours. And this is one of the highest ways to show, or most effective ways to show that you respect your clients and respect their time. And even if you don't have anything to tell them, just to call them and say, I got your message, X is happening, but it hasn't happened yet, then you've acknowledged that that you've heard their question and you understand their concern. And last is, if you are doing universal access right to counsel intake, or you're doing intake at a community-based organization where you have to get through a waiting room full of people and you can't do a lot of this, then tell them what you're doing now and why you're rushing them through it, and then tell them that you'll have time later, which hopefully you will, to have a longer talk. So I do universal access intake in the Bronx, or I did, in the crowded hallway, where even if the client wants to tell you your story, you might not want to do it where like 25 other people can hear it. So, you can do the first intake and get the demographic data that HRA wants, and then later have a longer phone call or meeting where you really have a chance to talk about the case and what's going on in the client's life, and how that is affecting the case. And all of this, establishing the relationship, is an ongoing process that may continue until the end of your relationship, whatever it may be. So it's not just you do the intake well, you have a very productive intake conversation, and then after that you just move back to churning through what you're doing with them. Does anyone have any questions on that specific part, the initial contact?
I don't have any questions yet. I just want to remind everyone, please put your questions in the chat as they come up, and then we'll be taking breaks to address them as we go along.
Okay, next slide. So creating structure is also something that should be done with all clients and is an ongoing process. It's especially important with challenging clients to do this early on, so they know what to expect from you. Anytime you meet with a client, tell them the purpose of the meeting or the phone call, and again, explain what that means. So don't call a client and say, I need you to come in to sign your answer, and not explain what an answer is or why the client needs to sign it. I've been doing this a long time, and I have definitely fallen into that pattern sometimes. So even whether you're new or senior person, it's good to have these reminders that things that have become so deeply ingrained in you are not deeply ingrained in other people. You set a time limit. And again, if you start this from the beginning of a relationship, people will expect it. And if you have a client who turns into a challenging client, imposing a time limit later on can be offensive and surprising, and a change in your relationship. And so if you start from the beginning, it really helps to that's just part of what we do. You're going to come in, you're going to sign the answer, we're going to go over it. It's going to take, I expect it'll take 30 minutes. And then again, this is also a way to show respect to the client and their time, because they spend a lot of time in waiting rooms for hours, not knowing how long they'll be there or who they're going to speak to. And if you have a client who does end up being challenging for some reason, either because of language barrier, education barrier, cognitive impairments, psychiatric impairments, allow longer meetings. And so when I say, set time limits, I'm not suggesting that once 30 minutes are up, you just kick the person out. And you can change your approach to certain clients. If you're 30 minutes in and you're still on paragraph 3 of the answer, then you know that next time you need to allow more time. And if you have time now, you can take it. Reassure the client that there will be time for questions and that you can meet and talk again later if everything isn't covered. A lot of times what happens is the client comes in and you put the document in front of them and start going over it, but they want to ask you questions. They want to tell you something that's happened since the last time you saw them. You can do that at the beginning of the meeting, but if you're prioritizing getting something done because there's a deadline, you can tell the client, I understand we need to talk about that. Let's go through this first, and then we'll talk about X issue. And that way they don't have to be anxious and wait for their chance to talk. They know they will have their chance. Tell the client what comes next. So your client has come in, they've filled out some paperwork, they've signed some documents. What are those for? What's going to happen? How long is it going to take? So client comes in, fills out a SCREE application. What are you going to do with that SCREE application? How long is it going to be before you hear back about it? It's fine to tell clients, I have no idea when I'm going to hear back about this, because that's true in a lot of cases. All of this helps focus the meeting, reassure the client what's going on, what's going to happen, what to expect, and what isn't going to happen. A lot of the clients that we are representing and assisting have a massive amount of uncertainty in their life, and to the extent that you can not contribute to that is really huge. It's significant. And the respect that you show your clients by respecting their time, and that they need to know what's going on. And it's not just like, oh, a conveyor belt of non-pays, you're next, you're next, you're next, you're next. Which again is sort of how the system is set up, at least in many offices with right to counsel. And it's really hard to push back against that and remember that you're not, it can be really hard to remember that you're not there for HRA, you're there for the client. And sometimes that means pushing back on some of the practices that have developed around right to counsel. And I'm not denigrating right to counsel. There are certain patterns that I think are apparent to everyone that need to be acknowledged and addressed to the extent that we can. Any questions on that or anything we've discussed so far?
There was one question. Can you give an example of explaining, sorry, I can't hear your story now, when we have to rush?
Sure. So my example is going to be the right to counsel intake in housing court. In the Bronx, MFJ does not have an office or a space, and so we were standing in the hallway with clipboards writing things down, which is awkward and uncomfortable for everyone. And so I would just say to the client, I have some questions I have to ask you. I have a couple of forms you have to sign. These are, this is required information that I need to get through today. I will call you before the end of the week to talk about, whatever additional stuff. Like I would get a very basic summary of their case for the intake, and then let them know that I would be calling them to get a better understanding of it and more details. And that serves two purposes. One, it means I can go and do another intake because there's usually people waiting. And it also lets the client know that I'm not just not listening to them. Does that answer your question?
Sounds good to me.
Dinah, I can add a couple other examples. Just this last week, I was staffing our mental health law project intake line, and I was starting to speak to someone, and it became pretty clear that he had a number of issues that he was grappling with, and I could see very quickly that I had other callers waiting to connect. The intake caller I was speaking to was a non-English speaker, so I was also working with an interpreter through language line. So just getting basic demographic information took longer. So I, just like Dinah described, I reminded him of the purpose of the call, which is, hi, I'm staffing our intake line today. I can hear that you are grappling with a number of issues. My role today is to take down basic demographic information. I'm going to forward that on to another case handler on our team who's going to follow up with you next week, and we'll be able to spend more time talking through these issues with you. But right now, I just need to get an overview, and I apologize, I have other callers waiting on the line. So reminding the person of the specific purpose of that meeting and giving them a concrete idea of what the next step will be and how their other issues will be addressed, or when time will be made to speak to their other issues. So I see there's another question in the chat. And I just want to say that I appreciate you all being here and working with us through this medium. This is new for Dinah and I as well. We would much prefer to be in a room with you all. And I know that many of you have extensive experience and a lot of great skills and strategies that you could and should also be sharing. So in addition to putting in questions or requests into the group chat, to the extent that that's possible, if you're comfortable offering up strategies that you use to address different situations, we can crowdsource and all be resources to each other. Okay, next slide, please. Setting boundaries. So again, like Dinah said, boundaries are important in any client work. They're important in any relationship, but they take on additional import when we're working with clients who may struggle with anxiety, managing anger, or acting in an abusive manner. They're also important in working with clients who have experienced trauma. In terms of sustaining our advocacy work, given the trauma that many of us may have experienced, or the vicarious trauma many of us may have we may have experienced in the course of our work, setting boundaries is an important way to sustain our practice and keep us doing the work that we do. So, boundary setting is important in terms of supporting the clear expectations around our roles that Dinah talked about earlier. And it's an important part of keeping our relationships healthy and constructive and productive. Boundary setting, like I said, in addition to sustaining our ability to keep doing the work that we do, they can also help model for our client or whoever else we're engaging with what it looks like to set boundaries, because they're also going to be needing to set boundaries in their life and in their work. It also encourages clients to tap into other resources they have. And I think it's important for all of us and our clients to tap into, build, and sustain wide networks of support. And so I've certainly found in my work as an attorney that when I focus on my role, which is legal support, I can encourage and support someone that I'm working with to seek support from mental health therapists or friends or family or peers for the other issues that they're grappling with. And that only widens the support network that someone has to look to when they're struggling in a crisis situation. So setting boundaries can mean setting limits on the length and frequency of contact. It can also mean setting parameters for the kind of contact or means of communication that you and your client are using to communicate. So for example, for some clients, I ask that they email me if they have access to email with their issue and let them know that I'll respond within 24 hours or whenever it's realistic for me to respond. Sometimes that means that phone calls can make more sense than in-person meetings. I know especially with our intake at MFJ, intake in person can tend to take more time, and we cover more topics or more ground than may be necessary or useful in an initial intake conversation. And so it can be easier to set parameters via a phone call. That said, I also have clients where I found it's difficult to get things done via phone, maybe because of disorganized thinking. One client in particular I worked with struggled with ADHD and had difficulty staying focused. And it was easier working with her to schedule in-person appointments because it was easier for me to redirect her or to focus the discussion in person. So, you know, over time and through experience, you're going to identify what kinds of communication work best for you in working with a specific client, and those will be individualized in regards to that specific client's needs and your specific needs in that working relationship. I also recommend, you know, with an anxious client who may be leaving a lot of voicemails, sending a lot of emails, letting them know that you're not going to be able to respond to every call, you're not going to be able to respond to every email, and let them know when they can expect a response. And I think some people feel guilty or like they're not being respectful if they're not responding to every communication. That maybe that means you're not paying sufficient attention to someone's needs. And I just want to encourage you that setting those parameters frees you up to do the substantive work that you are there to do, and that it also makes that work, again, more sustainable. So there might be some clients that I say, please, you're welcome to email me during the week as issues or questions or concerns come up. But let's know that I won't be able to respond to those emails, and let's set a weekly telephone appointment when we can talk through all of your issues at one time. And maybe that's every Monday at 3 o'clock You know that that's when we're going to be talking, and that's when we're going to review your issues. That gives the client a clear idea of what to expect, and it also gives you some breathing room so you don't feel like you need to be keeping up with a flurry of voicemails or emails throughout the week when you have other cases that you're trying to handle. When you do set limits, I think it's helpful, depending on the limits you're setting, to not only let the client know that these are the limits you're setting, but also if you have a supervisor, let your supervisor know of the limits that you're setting. So if there's an issue or if your client has a concern, your supervisor can support you. They understand the limit that you set, why you set it, and they will reiterate and reinforce that limit when they're talking to the client as well. I find that in setting limits, there's also limits about what I can't do, what's outside my role, not just communication limits. So I found it helpful when I am telling a client what I can't do, redirecting to what I can do, so that we can focus on what is possible in this specific working relationship, and then I can provide them referrals or resources if there's other kinds of assistance that they want or need. In regards to setting boundaries, I found that I often need to repeat or reinforce those boundaries. A lot of our clients and a lot of us generally have found that pushing boundaries can be a strategy that people learn to get what they want. So if I've been asking for something for a long time and haven't gotten it, I'm gonna start asking louder or more often. It's like the squeaky wheel gets the oil. So that's a strategy a lot of people use to navigate systems, including the legal system that we're a part of. So I often find myself repeating and reinforcing boundaries so that they're clear and that we maintain those boundaries. On the other hand, sometimes those boundaries are important to revisit in order to adjust, or I need to revisit to be more flexible if someone's needs have shifted. And so I think, like Dinah mentioned earlier, setting boundaries isn't a stagnant, rigid process that you do it and it's done necessarily. There are times and circumstances when those boundaries need to be revisited and adjusted. So for example, someone asked a question at the beginning or raised the issue of how COVID might be impacting people who already struggle with anxiety or paranoia or other mental health related issues. And certainly there might be clients that under normal circumstances, I might only reach out to if they reach out to me or if I have an update on their case. But given the current climate and the additional stressors that all of us are facing, I'm reaching out to people more regularly so that there's more constant and consistent contact. So I've adjusted the norms around communication. Sometimes you're going to work with a client who has difficulty managing anger or who is abusive. And I want to be clear that accommodating a client is not the same as tolerating abuse. And none of us need to tolerate abusive behavior. So if you're working with someone who is being abusive, you can and should end that meeting. You can do that respectfully. If there's a way to refocus or de-escalate, of course, I encourage you to do that. If refocusing and de-escalating does not work, then you can end the conversation and let the client know you're ending the conversation for this reason, and you can follow up with them next week, or they can follow up with you at whatever point when they're going to engage with you more productively. So I've hung up on clients. Sometimes you have to hang up on people. Again, I try and do it respectfully. There was one client who I worked with who was one of my favorite clients to work with, actually, but she really had difficulty controlling her anger, and she was very frustrated because she had been struggling with issues with her landlord for a long time and hadn't seen any change or hadn't gotten the results that she wanted. She directed her anger at me and other advocates she was working with. And so I would have phone calls with her, and she would start yelling, and she would yell. And I would try and redirect her. I would try and de-escalate. I would try and address the frustrations she was raising. And in that moment, she was not able to hear it. So I would tell her, Miss Smith, I can hear that you're angry. I can hear that you're frustrated. I want to talk about these issues. It seems like you're not in a place where you can talk about them right now. I'm going to hang up the phone, and I'll call you tomorrow and see if we can revisit this. And then I hang up the phone. I always try and empathize. I recommend acknowledging someone's anxiety and anger, validating their feelings. I explain and apologize for the shortcomings of the legal system all the time. And then I also recommend asking your client if there are things that you can do to make the meetings easier, less stressful. Do they prefer meeting in person versus the telephone? And if that's something that you can accommodate, you accommodate it. Do they prefer meetings in the afternoon versus the morning? And again, if that's something that you can accommodate, you accommodate it. Sometimes it's helpful for people to bring a support person with them. If you're able to accommodate it, you accommodate it. Although I would say don't offer to do something or give them an option that you're not prepared to follow through with. So be careful and clear in what you can accommodate and what you can't accommodate. I see a question in the chat box about inadvertently sharing personal cell phones. Yes, that's a really good question. It certainly happens. I think it's easier to avoid now with technology like Google Voice and whatnot, but it still happens. And I've asked people to not call my cell phone because it's my personal number, and I may not be checking it. If they need to reach me about a work call, they should call my work number. I think being honest and direct is appropriate. And I'm just looking at the other question.
Yeah, I just wanted to add to that. If they keep doing it, which I think is part of the problem, is that you just don't respond. Like, that's part of setting boundaries. You know, the client may have your phone in your number in their phone under Dinah, and you tell them not to call that number, but they have 3 numbers for Dinah. And so they just put in Dinah, and then they keep calling your personal cell. And they're just going to keep doing it if they keep getting through to you. And so part of setting boundaries, like Sandra was explaining, is sometimes you have to do something that feels harsh or rude, like ignoring someone's phone calls if they're calling you on a number you've told them not to call. And I actually have blocked a couple of clients on my personal cell phone because they couldn't stop calling. I told them I was doing it. It's like, you can call me at this number, and I'm going to block you from this number. Most of them stop after a couple of times, but it's fine. We do not have to be available to our clients 24/7. And that's part of drawing boundaries to protect us so we don't get burned out or have our own mental health issues from all of this.
Yeah, I remind people all the time that I'm an attorney. This is my specific role. I'm not a crisis responder, unfortunately, because people will deal with crises and they need a crisis response, but that's not me, that's not my role. I see another comment about including in email signatures language saying we can respond to you within X business days on our website or in an email signature. Do you have any recommendations for the wording? I've certainly seen language like that on people's email signatures, that I will try and respond to your email within 48 hours or within 2 business days. I would say if there is a period of time that you can commit to responding in, yes, you can include that language. I don't think it hurts to include that language. I think some folks don't always read the email signatures, so the message may or may not get across. I also think there are circumstances, which we all deal with, where we can't follow through or respond in the time we would ideally like. So I think, again, it's about committing to, agreeing to, or putting out there what you can actually commit to. I will try and respond to emails I receive as quickly as possible from clients, if only to say, I got your email and I'm going to respond next week. So you do what works for you. I don't have recommended language. I think the language that you included in the chat box is fine and appropriate with the time period that works for you. There's a question also, is it ever possible to be too blatant about limits and boundaries? I'd be interested or curious to hear if there's something Daniel Weinberg had in mind in terms of a particular scenario. It's hard for me to imagine a situation when you can be too blatant. I think honesty and transparency is really important, both for maintaining a productive client relationship and in terms of maintaining boundaries. So I want to be as direct as I can about the boundaries or parameters I have in working with me, but I want to convey those with compassion and respect to the extent that I'm able. I want to explain why these parameters in place, and also let someone know if they have questions or concerns or something isn't working for them, they should let me know, and those boundaries or parameters can be revisited. Thank you for that question. That was a really good one.
And one thing to keep in mind that I just want to emphasize really strongly is that if you set a boundary or a limit, then you have to commit to that. Because, for example, if you say to a client, I'm not going to respond to all your emails, but we'll talk on Friday at 3, and then you don't call them on Friday at 3, then any work you've done to develop trust and reinforce boundaries is destroyed because you've not fulfilled your side of the bargain. And that's, in a lot of cases, going to cause them to escalate their boundary pushing behavior because they thought they were going to be able to talk to you on Friday at 3 and they weren't. And so they are going to do more of whatever it was that caused you to set that boundary in the first place, because now they're anxious. They don't know when they're going to be able to speak to you. They don't know if they're going to be able to speak to you when you said that you were going to speak to them. So be careful about setting boundaries that you can't comply with. And if you have an appointment for Friday at 3 and you're in the middle of some sort of crisis, then call the client and say, I'm sorry, I'm in the middle of a crisis. I will call you X time. Don't just not call, because that just contributes to a lack of trust and undermines the relationship and undermines the boundaries that you're trying to set.
I agree completely, and it's often happened in my practice that I've scheduled an appointment and something comes up and that I need to adjust that appointment, or I'm not available when I said I would be. And when I've communicated that in advance up front, my clients have been very understanding. They also understand that life happens and emergencies come up. And my clients have accommodated me in terms of needing to shift things around when I've been upfront and communicative about it. If you can't reach out and make the phone call, but you have your client's email address and you know that they're checking emails, sometimes I'll shoot an email to say, hey, I know we were supposed to meet tomorrow at 12. I have something else that got scheduled. Can we push our meeting back? Or this has come up. I'll follow up with you at such and such a time to reschedule. And again, I found that my clients have been very accommodating. The one other thing that reminded me of, Dinah's comment reminded me of, is that I think in our personal relationships and in client relationships, it can be easy to think about boundary setting when there's a problem, or when something comes up and your boundaries are being pushed in a way that you didn't necessarily anticipate. And so I also want to say how important it is to set those boundaries at the outset of establishing the client relationship, because then you have a guidepost and something to fall back on. You're set up to address situations or conflict or boundary crossing when those moments come up, because you've already set some ground rules for how you're going to work together. Okay, next slide. But I'll pause for a minute. Did anyone else have any questions right now about setting boundaries? Something I think a lot of us do intuitively, but I also think it helps to take what we do intuitively and make it more, more explicit and concrete. Okay, refocusing the client. This is related to setting boundaries. So some of our clients may have disorganized thinking, maybe experiencing hallucinations or delusions that make it difficult for them to focus on the task at hand. Some individuals may be struggling with cognitive impairments. I mentioned earlier working with a client who struggled with ADHD. That meant that our meetings took a significantly longer than they otherwise might. And so because of these issues, it may make it difficult for a client to stay focused. They may also want to share things about their life or things that they're struggling with that aren't necessarily relevant, or share information in a non-linear fashion. So I would say when that happens, listening is still really important. I think it can get easy for us as advocates, especially when we know we have a concrete task to do, to tune out what doesn't fit within our square box of that task. But that's not respectful to the clients that we're working with, and we can end up missing out on a lot of really important information if we are tuning out and not listening to someone whose communication style may be different. That said, it's not disrespectful to interrupt and refocus. Again, I do that all the time. We're helping a client with a discrete issue, and our goals are not served by having too much unfocused time or taking too much time to talk about other issues they may be dealing with that we cannot actually assist with. I think it also can be confusing in terms of role expectations when we're giving too much airtime to issues that we can't assist with, because the more time a client is given to talk about those other issues, there may be some role confusion, and I may be setting up an expectation that I can do things that actually I can't do. So quite regularly, I'll interject. I'll say, I'm sorry to interrupt you. I hear that you are talking about this, and I need to go back to the list of repairs that you need in your apartment. Or again, like we talked about earlier, I hear you starting to talk about your history with this landlord and the harassment you've experienced. We can talk about that in a moment, but I want to make sure that we've gone through the list of money orders that you use to pay rent. So if the client is talking about something that's relevant to their case, you can interrupt, put that aside, let them know when you're going to revisit it. If they're talking about something that's not relevant to their case, redirect, remind them of what your role is, what you both need to do that day, and then encourage them to access other supports or people in their life to talk about other issues they may be dealing with. And then there are times when it's impossible to redirect someone. And so again, this one client that I had who really struggled with ADHD, I spent 8 hours with her over a period of days reviewing her answer. I have never spent that much time with anyone reviewing an answer. That was very unusual, and I don't recommend it as a general practice, but she was someone who was very engaged in her case, wanted to understand her legal defenses. She was doing her very best to stay focused and to work through the answer, but she just needed more time because she was distracted and more disorganized in her thinking. So we took the time that was required and we got it done. And I felt good about it, knowing that we had covered all of her potential defenses. She felt good about it, knowing that she understood what was happening in her court case and what defenses she had. So sometimes when you can and when it's appropriate, you just need to accommodate.
I want to add an example to that about refocusing. I had an owner's use case years ago, which in my experience, owner's use cases are just devastating because someone's home is, losing your home is always devastating, but in this particular instance, it tends to be a wealthy person taking someone's home, you know, for no fault of their own. I've been a good tenant, I paid my rent. And in this particular instance, my client had been living in his neighborhood for 30 years. He was deeply connected to it. The case was deeply traumatizing. We were putting in a disability defense, which is deeply traumatizing to reveal to someone who is trying to kick you out of your home. And so I spent a lot of time with him, listening to him talk about his history in the neighborhood, his history in the building, his history with the neighbors. And it was not, strictly speaking, relevant to his legal case. It's not something we were going to put into an answer or a motion. But in the end, and he was unbelievably difficult. He sent me the most abusive emails at 3 a.m. because he was also had bipolar disorder and would have mania in the middle of the night. And would send me just a series of awful emails that I would get in the morning. But I was able to resolve his case and get a settlement for him that he was happy with, because over many agonizing hours, he came to trust me. And I was lucky at that point. I was in the Mental Health Law Project, which has time and space to do that. But I guess my point is that there are no rules about like when you let someone go and when you don't let someone go. Talk. It's individual. It's on a case-by-case basis. You don't always know in advance. Like at the time when I was dealing with him, I couldn't see the future. I couldn't see, oh, this is all going to work out. I actually thought it was going to be a complete disaster the entire time. But I wanted to do my best by him. And so that's what I did, and it worked. It's not always going to work. So I think it's just a matter of developing relationships with clients and getting a sense of what they need. And when it is appropriate to just draw a line and then not cross it. Like I hear that you connect deeply to your neighborhood, but for now we need to, like sometimes you do have to let the client go and talk some more than you might otherwise, and some more than you might be entirely comfortable with. But like Sandra said, you have to be careful, because if I also had a client who wanted to divorce her husband, and I told her MFJ didn't do divorces, but I listened to her talk about her relationship with her husband and her divorce because I thought I was being nice and sympathetic. And she thought if she told me enough about the divorce that I would be sympathetic enough to represent her in it. So in that situation, I unintentionally opened the door to sort of misleading her expectations about what I would be able to do. Okay, so the next section is de-escalating. Clients are not only dealing with the pressure of the case, possible eviction, but they also be dealing with symptoms of mental illness, social isolation, poverty, physical illness, aging, and they may become agitated or angry to the point that it interferes with the purpose of your meeting or your representation. The most important thing, I think, when you are in a situation where the client is escalating is to recognize your own role or potential role in escalating. Because if you get tense or defensive or angry yourself, you're just gonna go right on with your client and just escalate. So be very conscious of your own voice and your own body language. I found it immensely helpful to myself to just speak slowly, low tone of voice, make sure you're breathing deeply. Even if you're extremely anxious by the way your client is behaving, make sure your shoulders are relaxed, your body language is open. If you're sitting up like this and you're tense and your face is angry, and it's going to communicate to the client that this is a tense and escalating situation. So stay calm, stay open, relaxed. Don't cross your arms, apologize where appropriate. I think one of the things that's really difficult as an attorney, especially when I was a younger attorney, is feeling like I was supposed to be the expert and I was supposed to know what was going on and I was supposed to be able to fix things. And so once I learned that I could say to a client, I'm really sorry, this is horrible. It takes forever to get a one shot, just acknowledge that the system is terrible. Maybe my system is terrible. Maybe MFJ is terrible. Maybe it took them 2 weeks to get assigned from intake to an advocate. Acknowledge that that's really frustrating and scary to not know who's going to be helping you. A lot of times that works to de-escalate it. You're acknowledging that they're frustrated and you're not doing it in a way that undermines their frustration. It's not like, I know you feel bad. It's acknowledging, you may have a role in that and that the bad feelings that they have are valid. Another important thing is to take a break. Offer the client water, a bathroom, walk around the block, go get a cup of coffee. Because one of the things that happens with escalating is that it starts and something has to break it. Like something has to intervene. And that intervention can be you being very calm and validating and acknowledging. The intervention can be just space and time. The client goes for a walk around the block, takes some deep breaths. If none of that works, then you may need to reschedule the appointment. And that's harder when the person is in your office and doesn't want to leave. If you're on the phone, that's obviously a much easier issued problem to face, like Sandra said, you can hang up respectfully. If they're in their office and they want to sit, then you reassure them that you're not kicking them out. You're going to continue helping them. You're not quitting as their lawyer or their advocate. Depending on how angry the person is, you can schedule a new meeting right then, so then they know that there's a future meeting with you. If they're too agitated to do that, then you still be very concrete. I will call you tomorrow. I will call you this evening to schedule another appointment, so that you're very clear that you're not making them a vague promise. You're actually going to take the next step to make another appointment. And explain that you want the meeting that you're in to be productive. So it's not, I'm kicking you out because you're yelling at me. It's, you know, I need to get this, we need to do this answer, and I want this meeting to be productive for both of us. And this isn't productive, so I'm gonna reschedule you to come in tomorrow or some other day. For abusive clients, I think that's on the next slide. Can you go to the next slide? Right. So a lot of abusive clients are just some of the behaviors that we've already been talking to, but escalated to a point where it's not tolerable. So some of the stuff we talked about already are things you should try. Don't get defensive, utilize de-escalation techniques, terminate the meeting, limit interactions. I've had clients that I did not meet with in person unless it was absolutely unavoidable. I had phone conversations. I've also had clients where if they came to the office, I didn't bring them back into the meeting rooms. I kept them in the lobby where there was, you know, a distance between us, plexiglass. I didn't necessarily think they were dangerous, but if things escalate, it's much easier to deal with someone who's at a remove than someone who's back in your office. Involve your supervisor and colleagues. At MFJ, we have a safety plan, and if your office doesn't have one, you absolutely should. So what we have is, if you have a client coming in who you know tends to escalate or get angry or get loud, tell people who are in the offices around the meeting room, tell your supervisor, and in some cases you can just tell them, look, this client likes to yell, it's fine, you don't need to worry. And in other cases, you can say, this client tends to escalate. If you hear him yelling, can you please come poke your head in the door? And what I was talking earlier about de-escalating, like needing a break, sometimes having someone open the door and say, hey, what's going on in here, can be the break that is necessary. But when that happens, it has to be done in a non-confrontational way. So don't open the door and say, stop yelling at Dinah. You know, don't open the door and say, you're too loud. You can't be this loud in the law office, you know, stuff like that. It has to be an open question, like, is there anything I can help with? Because that gives the chance to the client to answer the question. Like, you're asking how they're doing, what's going on, is there anything you can help with? And that might calm them down, that might de-escalate the situation. If that doesn't work, then the next step in our safety plan is multiple people will come. And again, it's not intended to be threatening. It's intended to show the client that there are other people around who are concerned about what's going on and who will intervene if necessary. And at that point, almost all of our clients either leave or de-escalate. If they refuse to leave at that point, then what we usually do is no one stays seated at the table with the client. You stand up, you stand in the doorway sort of to physically indicate where you want them to go. People stand around, talk to them from a standing position about what they're going through, trying to get them to leave. And sometimes that takes a really long time. I remember one time last year, I think the woman was in the meeting room for over an hour while 2 or 3 people stood in the doorway and tried to talk to her, set another meeting with her, convince her to go to the lobby. And it took a long time, but she did finally leave. Yeah, I think that's mostly it. It's a lot of the same stuff we've already talked about. Any questions about that?
I don't see any questions.
Okay. Sandra, did you have anything you wanted to add?
No, just in addition to having a safety plan or not meeting with a client in an enclosed space if you're concerned that the meeting could escalate. There are some clients I work with that I try and always have another attorney or my supervisor or someone else in the room, not necessarily because I'm concerned about safety, but if I suspect that the conversation might escalate, sometimes it just helps to have a different voice in the room. So maybe I've said something to my client before, and for whatever reason, they can't hear it from me. And so hearing it from someone else can often make the difference. So there are some clients that in our office will say are two attorney clients or two case handler clients, both to reinforce any boundaries, reinforce each other, and also be a different messenger.
Yeah, and on that, I hadn't really thought about this, but one thing that's notable sometimes with clients who get to that position of needing a second person is having a supervisor come in can be really helpful, even if the supervisor just says what you said or reinforces what you said, because they're higher up on the hierarchy. And so if someone is really angry and frustrated, speaking to the boss can be satisfying and make them feel like they've been heard and their problem has been addressed. For some people, it will make it worse, like, oh, you're just taking her side because you work with her. But I have noticed that a lot of folks will appreciate hearing from a supervisor, oh, this is actually the recommended path in this instance. Here are two people telling me this, including my case handler's boss. The next slide. Okay, delusions and hallucinations. First, never argue with the substance of a delusion. You will not convince a client that whatever delusion that they have is not real or accurate. And if you try to do that, it's going to destroy their trust in you. And they may incorporate you into the delusion depending on what it is. The other challenge with delusions and hallucinations is that they are presented in the media as scary and threatening. And if someone has delusions and hallucinations, then they're really ill. And I've had clients with delusions and hallucinations who had the capacity to work in their case without a GAL or an Article 81. So you cannot assume that someone lacks capacity because they're having sort of very spectacular, outwardly obvious mental health symptoms. One example is a client who has been one of MHLP's forever clients. You know, we have folks who come back every year or two. And he has persistent delusions that he's being surveilled, and he's very, he seems to have accepted that this is just his life. These entities are surveilling him. They know where he's going. When he comes to our office, they know he's going to be there. So he's asked me in the past not to reserve an interview room when he comes in to meet, because if I do that, then they will know where he's going to be exactly and they can surveil our meeting. And so when I meet with him, I make it clear to him that I did not reserve a meeting room. Like, we walk down the row of meeting rooms and just take the first empty one. There was also a time when he didn't want to come into our building at all because it was entirely malevolent to him. And so we met around the corner in a deli. But none of this affected his ability to understand the case He had a long history of litigation with his landlord, and he remembered all of it. He had his documents. He had a folder with all of them. He understood what I wanted to do and what he should do. Meetings with him did take longer because he was hearing voices, and so sometimes he would pause and he was listening, and I would have to sit there, and then he would say something to me that was possibly influenced by the voices, but possibly not. But he did need to go over things multiple times, I think, because he had different stimuli going on. He had me, and then he had the delusions. But I never considered moving for a GAL or anything for him because he didn't need it. And I had another client who was more limited than him, floridly psychotic. He believed that there were aliens taking over 3 Mile Island, like very classic sort of delusions. But he had a non-payment case, and he needed a one-shot deal, and he had a rep payee for his SSI. So again, I didn't move for a GAL because those are problems that could be resolved with me and his social worker at his treatment provider. So again, don't be intimidated by delusions and hallucinations, and don't assume that your client lacks capacity because of them. The hardest thing with delusions and hallucinations is when your client wants help with the subject of the delusion. You're a lawyer and the CIA is monitoring them. What can you do to help them? And in that situation, again, it's just limiting boundaries and limiting scope. I'm a housing attorney. I cannot help with surveillance or tracking or stalking. And it's the same sort of response you would have if someone asked for help with their divorce. It's just not something you can help with. And that's how you have to approach it, because you cannot say to them, the CIA is not tracking you. Also talk about how there's not a legal remedy for every wrong. I think people think sometimes that, oh, I just need a lawyer and they can sue, but there are a lot of wrongs in the world that can't be resolved by lawyers and lawsuits. And that's another way to approach it, is I just don't know that there's a legal resolution here. And you can refer them to other organizations, even if you know the other organizations are not necessarily not going to be able to help them. The other organizations may have experience and processes for dealing with people with these situations. The pro se clerk at the Southern District did a presentation at MFJ many years ago, because obviously she gets a lot of people coming in who want to file federal lawsuits against various federal entities that are surveilling them. And so this is not new to her. It wasn't new to her staff. They knew how to interact with people in this situation. We can refer people to the City Commission on Human Rights for discrimination based on disability that appears to be, based on delusions. They also have experts. The city bar has an intake line that deals with these sorts of calls. It's just something you have to deal with, and it can be really uncomfortable to send someone to another organization knowing that they're not going to be able to help, but it's also not your job to convince your client that there is no help out there for them. I think in some cases they need to do that work on their own and make that discovery on their own. Sandra, do you have anything to add about delusions?
I would just add that sometimes there are going to be ways in which someone's delusions impact the litigation. For example, I worked with a client who had a non-pay case, owed rent arrears, and part of his delusion, the manifestation of his delusions, was that he was connected to a lot of big shot celebrities, and he was one phone call away or 1 week away from landing his next music album or landing a role in some new film that was going to give him the money to settle his rent arrears. And so that was a situation in which his delusion was potentially getting in the way of us creating a realistic plan to resolve the rent arrears. It was hard for him to understand why applying for a one-shot was necessary when next week he was going to get an $1 million check and he'd be not only able to take care of his arrears, but also buy his own apartment or move somewhere new. So in that situation, you know, I didn't argue with his delusion. I congratulated him for the job that was going to be landing his way. But I also explained that because he didn't have the check in hand that day, it was still important that we go through this one-shot application process. And he did, we did, the arrears got paid, and we got the case resolved.
I just want to acknowledge there's a question in the chat. It says, we have clients who said neighbors or the landlord are piping noxious gas into the apartment. I believe that we asked them to call 311 and see if the city can verify. Does that seem like a reasonable response?
Yeah, I think one thing that became evident in the last 2 years, there was a lot of press, I think maybe 2 years ago, about landlords destroying people's apartments as a way to drive them out. And so one thing to be aware of is that someone may call with what sounds like a delusion and it's not. Like maybe the landlord did come in with a sledgehammer and destroy their toilet, because that has actually happened. And so in cases like that, yeah, like call 311, get a city inspection. Do you have pictures? Do you have witnesses? You're not challenging what they're saying, the truth of it. You're inquiring as an attorney about the sort of evidence you would need in court. So, you know, if we go to court and you tell the judge this and the landlord denies it, then the judge has to make a decision based on your word versus the landlord. But if we have pictures, if we have violations, if we have a video, if your cousin saw it, you know, so that way, that's another way to approach a situation where the delusion is a subject of the case that you're in, or is it, you know, like Sandra's case, impeding your ability to go forward with the plan that you think is best, is that ask the client for proof. And then if they can't come up with it, then again, you can have a discussion about the legal system, and that the legal system exists not to find the truth, but to find, you know, between two parties who has presented the most credible evidence. So that's what I would do with noxious gas or any of the other, like, destroying their belongings, that sort of thing.
And I see another question about a tenant who seemed to believe that two separate apartments, maybe neighbors, were causing the floor to move or vibrations of the bed. Seems similar to the previous question. Do you have any thoughts?
No, I think it's a similar thing, is asking if they can provide some sort of proof. Do they have a friend who can come over and look at it? Can you come over and look at it? You want to be careful about going to clients' apartments, but we do home visits at MFJ. Sometimes we do them in pairs, depending on your office's policies. You can go look at the apartment and see what you can see. So again, I would put it back on the client to produce some kind of evidence of it, and you can work with them on that, make suggestions. You don't want to get dragged into a futile effort to provide evidence of something that you don't think exists, but you can give them the tools to get that evidence. And if they come back with the evidence, which again is possible with some of the things that landlords do, then great.
And And I would just add, in regards to the question about vibrations, my approach might depend on the case in which those reports are being made. So if there's an eviction case in which the tenant's tenancy is on the line, I might respond differently than if someone's approaching me to affirmatively sue their landlord based on bothersome vibrations. I think everything that Dinah described still applies in both situations, but in a case where the tenant is facing eviction in housing court, I usually remind people that I am an eviction defense attorney, and I understand this living situation is difficult for you. The current case we're in is not your case. You're basically the equivalent of a defendant. It's your landlord's case. And so my job is to make sure we save your home. And then if there are other steps you need to take to improve conditions in the apartment, or if you want to relocate to a different apartment, you're going to be better positioned to strategize once your home has been secured. So I try and focus on, again, the very narrow issue that we're there to resolve. Any other questions about delusions and hallucinations before we move on? Okay, so I see a question. Difficult situation where delusions are leading the tenant to engage in nuisance behavior, such as repeatedly calling HPD or filing civil and criminal complaints against the landlord for identity theft, various fraud theories, etc. So I think some of the approach that Dinah described earlier applies in this context as well, where it may be helpful to remind the tenant that the question that the court is looking at is not necessarily a question of truth, but a question of credible evidence. And that the court's authority and jurisdiction is limited, and that there isn't necessarily a legal remedy to all of the injustice that the tenant may be experiencing. Dinah, do you have any additional comments on the specific question about repeatedly calling HPD?
Yeah, just when we have nuisance cases with allegedly problematic behavior, you know, I've tried to address with the client, you know, whether they can control or limit the behavior themselves, like take them through the steps, like of where this case is going. And then once you get to the point of, okay, what will you do to avoid eviction? Then some tenants, depending on the extent of their mental illness, will say, I'm going to make the choice to stop calling HPD if it means I can stay in my apartment. And part of that process is asking open-ended questions. So if you just say to a client who's going through something like this, if you keep doing this, you'll get evicted, is less effective than, you know, what do you see the outcome here? Oh, I'm sure the judge will believe me. So then walk them through in an open-ended question, a series of questions where they explain to you what they want to happen and what they see happening. And you have a conversation about that. And then a lot of times you'll hear a client say, well, I'll just move. And then ask them, okay, where will you move? Have you looked at apartments lately? What are the rents like in your neighborhood right now? So sometimes that will get people to back off the problematic behavior. A lot of times it won't, because it is beyond their control. They're doing it due to hallucinations or delusions, and it's not something that they can just stop doing. And in that situation, sometimes we've tried asking the person, will they enter into mental health treatment? That's a very touchy thing to address with someone who does not believe that they are mentally ill. But a couple of ways to approach it are, I think it would help with this case to have an expert opinion on your mental health or your alleged mental health. Another approach is, this is extremely stressful, the possibility of losing your home. I think it would be better for you to have someone to talk to about that who's not an attorney. Sometimes people will enter into mental health treatment if it's framed that way. And then once they're in mental health treatment, you can hope that the treatment provider will be able to make some kind of progress with them, which is, again, not always going to happen. And then if none of that works, then you argue it's not a nuisance. It's not a continuous and ongoing invasion of rights. And that's a legal determination where you have to do your best.
Yeah, I agree with all of that. And I would add, depending on the circumstances, it may be useful to direct a tenant to steps that they can take in terms of identity fraud response or protection that is outside the context of making complaints, but maybe giving them information about putting a hold on their credit report or getting a new ID. Sometimes that can be helpful in terms of redirecting someone's energies. Sometimes it's not. I think in these situations, we try different tactics, different ways of engaging, and sometimes they work and sometimes they don't. Again, reiterating something that Dinah said, but in different words, sometimes it's about reminding the tenant that our goal is to, keep someone in their home, and the courts are not set up to deal with every injustice, or there may not be a legal remedy for every injustice. And so what support do you need? And maybe that's mental health support to be better able to cope or live with this injustice. I think, these situations push us as advocates to be creative. And I think it can be really helpful to reach out to colleagues or other advocates to brainstorm and strategize different tactics. But unfortunately, there aren't any easy answers or a one-size-fits-all approach. There's another question here about circumstances of individuals who are not aware or deny that they have serious mental illness or underlying delusions. Again, I think it depends on the extent to which the mental illness or the delusion is impacting the litigation. Like Dinah described, sometimes it doesn't impact the litigation at all. And it doesn't matter whether someone acknowledges that they may have mental illness or acknowledges that they have a delusion. Sometimes it does impact the litigation, and then we as advocates are in a position of troubleshooting. How do we address the litigation issue? I don't think our role is to address someone's mental health or mental illness. I'm not a medical professional. I can't diagnose someone or say what's going to be most effective or supportive in terms of any kind of mental health treatment. So I see my role as troubleshooting the litigation issues, and then also making sure that someone's aware that there are resources out there if and when they are wanting to seek additional mental health support. Again, though, in regards to situations where someone may be in denial or doesn't want to admit that they may have a mental health disability or mental illness, there are situations, again, like Dinah described earlier, when I'll still encourage someone to get treatment, but I link that to their legal case. So I might say how a letter from a therapist or a mental health treatment provider could assist in getting them the apartment transfer that they're looking for, and explain why that might make a difference. Or say the judge is going to look more favorably on your case, or we're going to have more evidence to present at trial if you are engaging with mental health services. You know, we have a lot of experience handling these kinds of cases, and we know the judge always asks, are you engaged in mental health services? So it behooves you, even if you don't want it, even if you don't need it, even if you opt out after this case is resolved, but for the duration of us litigating this case, it's going to benefit you legally if you opt into these support services, whatever they are. Okay, moving on to the next slide, please. Involving family members and treatment providers. So that's a good segue. Sometimes it's important or necessary to involve family members, friends, or treatment providers. Why? Because those people can be additional supports for a tenant who is navigating a stressful court case. They can expand the advocate's capacity in terms of being an additional support and or buffer for someone who needs or wants more frequent communication. They can provide important background information and medical support to further the litigation goals. Family members, friends, or treatment providers can be really useful sources of information, particularly if you're working with someone who has memory deficits, maybe speaking to their therapist or a family member to get a better understanding of the history of the case or the steps that occurred before the case reached your door can be really invaluable. We recommend that you only engage family members, friends, or treatment providers with the client's permission. As an attorney, that's part of your responsibility in terms of the rules of professional responsibility, but it's also important in terms of sustaining a healthy and productive client-advocate relationship. So I always ask a client's permission in terms of who I reach out to in regards to their case. Even if I'm reaching out to their landlord or their landlord's attorney, I'll ask, is it okay if I reach out to your landlord about this? Is it okay if I reach out to your sister about this? Is it okay if I speak to your therapist about what's been going on here? And I'll not only ask for permission to reach out to the specific individual, but I'll also have a conversation with my client about the scope of the conversation they're authorizing me to have with that third party. So I might say, I want to talk to your therapist because I'm going to need them to write a letter about their work with you, how often you've been meeting, any medication that you're taking, et cetera, et cetera. Is it okay if I reach out to your therapist about these topics? Or I'd like to talk to your roommate to find out what conversations they've had with the landlord about these repairs, so I can document all of the requests that have been made. Is it okay if I contact your roommate about that? So I not only get the permission beforehand, but I also offer to report back afterwards and let them know what came out of that discussion, if that's something that they want. So I try and maintain the client's involvement as much as possible. And I let the client know and remind the client that they can revoke that permission at any time. I'm their attorney. The information that they give to me is their information, and they get to control, for the most part, who I'm communicating with and what I'm disclosing. And I have had clients give me specific directions in terms of, I want you to talk to my caseworker about these things. I don't want you to talk to her about these other things for this reason. And I let my client know that I'll respect their wishes, and I report back after the conversation so that they can have some assurances that the discussion remained within the scope of what they authorized. There are situations when it's helpful for a treatment provider to know what's happening in the legal case. And so I'll also ask my client, do you mind if I give your social worker an update or keep her apprised about what's happening? I think she might be able to assist in these ways. And more often than not, my clients will give me that permission once they understand why I'm asking for what I'm asking. Like I mentioned earlier, sometimes treatment providers need to provide letters or documentation to support a defense or as part of the litigation. And so in those situations, it can be difficult sometimes to get a doctor or a therapist or a treatment provider on the phone. They're also juggling a lot of patients and a lot of work. So when it's possible, we try and alleviate the work that we're asking them to do. So if I need a medical support letter for a reasonable accommodation request, I'll have a telephone conversation with them, get the points that they can support or their opinions on the topic, and then I'll draft a skeletal letter for them. They ultimately need to review the letter to make sure it accurately captures their opinions. But I do want to help alleviate the work that I'm asking them to do, because then there's a better chance that they'll actually be responsive. Dinah, do you have anything to add about involving family members, friends, or treatment providers?
Yeah, just one thing about the importance of maintaining the attorney-client relationship. A lot of times with people who may have very serious like illness, functional impairments, you'll get contacted by a family member or a social worker or a therapist to do the intake, and you'll do a lot of the work through that person because the client has Alzheimer's, or they are hospitalized on inpatient psychiatric unit, and the person that you're speaking to has all the information. They have the history. Like Sandra said, they can be very helpful in giving you context, and it can, quite frankly, be easier to go to them and say, oh, I need a one-shot deal. Can you help with this? But you have to be careful about that, because a lot of times these are also family relationships which have a lot of baggage. And I have more than once had a client say to me, a year into the case, when I've been working primarily with their sister, with my client's permission, like, oh, I've always hated her. She's always in my business, and she's never thought I could take care of myself. I don't want you to talk to her anymore. And by that point, I have not developed a great attorney-client relationship with my client, because I was working primarily with her sister. And it was being done with my client's permission. But I should have done more to report back to her, like Sandra was saying that she does. That's a great that's a great practice. And it's something to keep in mind, because you just really end up in a bad situation if you represented someone for a long period of time and you don't know them. And that's not always going to happen. And some clients are going to say, why are you calling me about this? I told you to deal with my sister. So you have to balance that, and there's no one size fits all. Just want to caution against situations where you slide into dealing with the easiest person, most responsive person to deal with, when that person is not your client, because it can lead to trouble down the road.
Yeah, that's a really good point. And I think we want to be cognizant of legal conflicts of interest and also the ethical conflicts of interest. And I have a client right now where his mother referred him to our office, and she was a very strong advocate on behalf of her son in terms of following up to see where we were in the intake process and would we be able to represent her son. They both were named as respondents in a nuisance type case. And then when I actually reviewed the court file and the allegations, I saw a lot of the allegations were reported by the mother, as in the mother had called the management office to say my son has done A, B, and C. So she was the source of a lot of the fodder that the landlord used in bringing that case. So yes, when dealing with family members, we all know that family relationships are complicated, and we want to be cognizant of how those complications are impacting our client's decision-making, and also how those complications might be impacting our role as advocates. So next slide. So we spoke earlier about certain situations when you might want to refer someone to treatment. I certainly have clients also asking me, how do I connect with mental health services? Some people want additional mental health support. So NYC Well is a great resource. There's a phone number. Someone can also text. Like Dinah said earlier, you can refer for additional support in regards to the stress of litigation. You probably shouldn't say, I think you need mental health help, or I think you're mentally ill. But let someone know that there are resources out there if they think those resources would be helpful. In making a referral, it can be helpful to acknowledge the stigma around having mental illness or needing mental health supports, as well as the negative experiences that someone may have had with the mental health system. A lot of people, if someone's been hospitalized in the past involuntarily, that's a very traumatic experience, and that may prevent someone from reaching out in the future for mental health support that they actually need or would benefit from. And acknowledging that is important, I think. It can then also open up a conversation about the differences between involuntary hospitalization and voluntary outpatient or peer support options. In addition to hospitals or clinics, there's also clubhouses, which is a great peer advocacy model. Fountain House and Venture House are two more well-known ones in New York. If you're interested in clubhouses, feel free to email me after or look up online. They're a really great resource, I think, an underutilized resource. Respite centers are also, can be helpful. Someone who's experiencing mental health decompensation, like maybe decompensating, may need a break from their home, from their environment. a respite center can be a good option for a getaway, a reset, different environment. If your offices don't have a social work department, I highly recommend trying to establish one. It's incredibly useful to have social work support on hand, and we rely on our social work director and her team heavily. And I see there's a question about clubhouses, Venture House, Fountain House. There are other ones too in different communities, so you can look online or you can email me after. Any questions about referring for treatment? Anything you want to add, Dinah?
No.
Okay.
Okay, next slide. So this is not a training about GALs and Article 81s. That's a large topic, but we did want to address those because they come up in the housing context when there's litigation, especially. And especially if you're an attorney representing someone who you think may have limited capacity, the question is, what can you do about that? So the New York Rules of Professional Conduct do allow you to refer someone to, for example, APS or other outside help when they are at substantial risk of, risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in the client's own interest. So that's the rule that allows an attorney to refer someone to APS. But I think an important part of this rule is, first of all, it should be a last resort. Referring someone for an Article 81 or a GAL against their instructions is an exception to the attorney-client relationship. And it's a serious exception and not something that you should take lightly. And part of this exception is that you can refer or consult with individuals or entities that have the ability to take action to protect the client. So in that situation, I think, like, for example, if you have a no defense holdover, your client is going to be evicted on Friday. She has no place to go. So she is at risk of substantial physical, financial, or other harm because homelessness, I think, would qualify. Do you refer her to APS against her will? I would say no, because APS under that circumstance does not have the ability to take action to protect the client. I mean, we can argue about the function of APS and what they do and don't do, but if you believe that the entity that you're referring them to is not going to take action to protect the client, then I don't think you should make the referral. Because that's, in my opinion, it's a two-part question. Is, are they at harm? And is the entity that you would refer them to able to do anything to mitigate the harm? The comment to the rule, to Rule 1.14, also says, hold on, let me back up. So does anyone have questions just about that? Not so far. Okay. So if you're wondering also if your client needs a GAL, some questions that I ask is, you do an interview, and again, you do open-ended questions. You don't say, do you understand what's going on? Yes or no. That's pointless. So you do an interview to ascertain if the person understands the nature of the proceeding, if they understand why they're in the proceeding, if they understand the consequences of the proceeding, if they can act to make decisions in the case, if they can do what is necessary to participate in the case. And if you find that they are limited in any of those areas, then you also need to keep in mind that to protect their autonomy, to the greatest extent possible. So there's a concept that you may be familiar with called the least restrictive alternative, and it's the concept in disability law where the person is entitled to maintain her autonomy and independence to the greatest extent possible. So you should not petition for an Article 81 if a GAL would do. Likewise, if your client would take voluntary steps that would eliminate the need for a GAL, then you don't move for a GAL. So in cases, for example, in non-pays where our clients are unable to manage their own money, you can refer them to APS for a GAL or for money management, or you can help them set up automatic bill pay. And in a lot of cases, setting up automatic bill pay resolves the problem while preserving the client's autonomy and keeping APS and GALs out of their lives. So anytime you have a situation where you think the client needs an additional assistance, try to respect their autonomy and do the least restrictive thing possible, and really question whether you need to make that referral or take that step if your client has advised you not to. The last point, which is related to Article 81's, can you do the next slide? Is motions to withdraw. So part of the rule for motions to withdraw is to take protective action before you move to withdraw. So if you're considering moving to withdraw under 1.16, it'll refer you back to 1.14 to explore whether you should refer to APS or explore an Article 81 guardian before you move to withdraw. And these are the ethical rules of our profession. I'm not an expert on them. I'm just explaining to you what they say. I think it's not straightforward at all what you should do in situations like this. But I did want to talk about motions to withdraw quickly because I think they should be an absolute last resort, because your client is not going to be better off without you, no matter how disabled they are. And I think there have been some concerns raised with right to counsel and the limited ability to take the time to utilize some of the tools we've described today. Is leading to like difficult clients, high need clients, time consuming clients, having their attorneys move to withdraw because of the pressure for numbers under the HRA contracts. And that's not acceptable. It's not providing accessible services. It's not providing, providing discriminatory services if an office cannot adequately represent someone with a serious and persistent mental illness without moving to withdraw. And I think, so I included that in this training to flag it as an issue that I hope your offices will take really seriously. And this isn't a training on motions to withdraw. It's an incredibly complicated issue when you should or shouldn't do it. But wanted to make sure to include it. Sandra, do you have anything to add?
Yeah, not about motions to withdraw, but about taking measures that your client may not agree with. So everything that we've talked about today, it's all interrelated. And so in regards to measures that a client may not agree with, whether that's financial management or whether it's asking for a guardian ad litem, hopefully, if you as the attorney or the advocate have identified, for example, that someone needs or would benefit from financial management, but your client isn't agreeing, hopefully you've been able to do the trust building work in that relationship, where possibly if you have a conversation about why you're recommending financial management, they may reconsider their position. Again, they might not, and I've worked with plenty of clients who have a position, they're not gonna engage with APS, so they're not going to consider financial management, and there's nothing I can do to convince or persuade them otherwise, and their wishes direct me. But there are also plenty of situations when I talk to someone about why I'm recommending they consider financial management, and I also talk them through how they can opt out of financial management down the road if it's not working for them. And sometimes then a client will reconsider their position. So I think that is all that we had planned to cover, and we're almost at 4 o'clock. But if anyone has additional questions or comments, you can put them in the chat and we'll try and address them. Thanks to all of you for your patience and your work.
Great. So I just want to thank you, Dinah and Sandra, for this presentation. It was very helpful and useful, and we appreciate your time. And also thanks to everyone who did attend the training today. This is the last training in our spring training series. We are putting together some trainings for the summer because we're still going to be working from home. So stay tuned for that. And yeah, thank you so much, everybody.